Perfect. Well, good morning. Thanks for those of you who are joining us for our last Get It Done Week session. We are now to our final day on wills, trusts, powers of attorney, and estates. So I will hand it off to our two presenters, Mark Bobatek with Golden Oak Elder Law and Byron McFarland, who is our Register of Wills for Howard County. With that, I will hand it to our presenters. Thank you for being with us. And Mark, take it away.
Tiffany, thank you for the Horizon Foundation's sponsorship and your hard work to make this happen. We really appreciate it. So good morning again, everyone. As Tiffany told you, my name is Mark Bobatek, and you can say Bobatek or Bobatek, but if you call me Mark, we're good. I've been an estate planning and elder law attorney here in Howard County for a little over 25 years now, and I own the tiny firm named Golden Oak Elder Law. We have a lot of ground to cover today, so without any jokes or further ado, I'd like to introduce our honored guest for this workshop. Byron McFarland is the Register of Wills for Howard County since being first elected to the position 8 or 10 years ago. Is that right, Byron?
10 years.
8?
10 years.
10, okay. Byron is a Howard County native, and he says he was first inspired by a high school teacher at Glen Elk High School to vote. And then he started watching C-SPAN, and then he interned with the county council, and after college worked with the Maryland General Assembly. And there he learned about giving great constituent service. And folks, I want to say, as a frequent user of the Register of Wills office, that they give great constituent service. And although they're not allowed to give you legal advice, they really take great care of families at a very tough time when people are in distress. And so Byron has a whole team of wonderful people, and we are blessed because, as we've seen from recent elections in candidates who are running for office, there's a large variation in their honor and their compassion and their commitment and their competency of they and the people around them. So we are really, truly blessed to have Byron. Anyway, he says that that politics can be a great way to create positive change, and that he's had a chance to prove as Register of Wills to everyone who he comes in contact with that government can work for them in a positive way. So welcome, Honorable Byron McFarland, and thank you for joining us this morning.
Thank you, Mark.
All right, I'm going to share my screen now, and we are going to go through a little bit of an outline, and our goals are going to be in the next 30 minutes to help you in the audience decide whether you should try to do your will on your own or whether you need to get some legal guidance. And so we want you to remember that this is general advice only that Byron and I are giving you, and it's not intended to be specific legal advice for you. If you have a question that involves legal advice, you've got to ask a lawyer. You really can't even ask the Register of Wills staff. They can tell you what the law is, but they can't tell you what to do. Any comment on that, Byron?
Yeah, we get phone calls all the time. We have people who come to visit us, and they want help with all of the estate planning side of things, but really we can explain the process for what happens after people pass away. But when it comes to writing your will, advance directive of trust, what package of estate planning tools might be best for them, we can't give that kind of advice. So we can walk you through the process, but we can't help you decide what's best for you.
And Byron, that takes us to our first question on the agenda, which is, what is probate, in about 30 seconds?
So probate, very simply put, we also call it estate administration. Probate is the process of basically dealing with all of your assets after you've passed away and figuring out who gets paid what, essentially, who gets to serve as your personal representative. You've also heard that called the executor. Usually it's a pretty simple process, but it's really just sort of a matter of figuring out if there's a will. If there's a will, we follow the terms of the will. If not, we'll follow what are called the laws of intestacy, which we're going to talk about, and figuring out what the assets are. In probate, and this is a really important point, is that probate only deals with assets that are titled in your name alone or with no beneficiary. So any assets that you have that are jointly titled or have a beneficiary do not come through probate.
So you can see that that's question number 2 here on our outline. And it's very important. You need to think that any joint ownership or beneficiary designation will take priority over your will. And your will will only, or your intestacy, if you didn't write your own will, the state wrote one for you. That will take, all those other forms of ownership will take priority over what you have said in the will or what you've allowed the state legislature to say in the will that you didn't write for yourself. So Byron, let's go over really quickly what the state legislature wrote as the will for the people who don't write their own. What if you're a single person and you have no children?
Well, that's me actually. So I know exactly what would happen. I'm not married, I don't have any children. So the way that it works is, our intestacy laws, so the laws that govern what happens when you die without a will, that determines who gets to serve as your executor and who gets to inherit. And so for someone like me, it's actually really simple. Both of my parents are living, they're divorced, but they're both living. So if I passed away right now without a will, my parents would inherit my estate equally 50-50, and they would both have equal priority to serve as my personal representative.
Byron, I think you have one sibling, right? So if your parents weren't living, then it would go to your sibling. How many
Actually, I have a
siblings?
brother and sister, so if
Oh,
my
you have
parents
two,
weren't
okay.
living, it would go equally to my brother and sister, right?
Okay. Now, suppose you're married and you don't have kids. How would that change?
If I were married and didn't have children, if I had been married for at least 5 years, my spouse would get everything. If it had been less than 5 years, my spouse would get the first 40,000 and then half of the rest, and the other half would go to my parents.
Okay. And that's interesting. And that 5-year distinction is actually a fairly new Maryland law. There
Right.
used to be no distinction based on how long one is married, and now there is. And notice, folks, so what that means is that even if you are married, your spouse is not going to get everything. If your parents are living, they are still going to get half in some cases if your marriage has been less than 5 years. Okay, well, we need to move on. Suppose you're married and you do have children. Then how would it be divided without a will?
So basically the same as I just described. So it would be the first 40,000 plus half of the rest to your spouse and the other half to your children.
Okay, so thank you. So folks in the audience, if that's the will that you want for yourself, you may not even need to listen any further because that's what the legislature has written for you until you write your own. And once again, I want to remind everyone that this only controls the assets that are solely in your name that don't have a beneficiary designation and are not joint with someone else. If they have a beneficiary designation, they will go to that beneficiary regardless of what your will says. And if they are joint, usually joint is tenants, joint tenants with rights of survivorship, which means that it would go to the surviving joint owner. It is possible to create a joint ownership called tenants in common, where there is not survivorship and where the half owners half would be probated through their estate. That's a little complex and it's beyond the scope of today, where our real goal is to teach you the basics of what should be in a will, what shouldn't be in a will, and whether you think that you need to get legal help to create your own will, etc. All right, so number 4, what things should be included in a will? And I don't know what Byron's take on this is, but I really don't recommend handwriting your own will. I really recommend paying the 50 or 100 bucks or whatever to use software, at least if you're doing it yourself, or follow a form. So first, you make sure you want to state your name, and it's also good to include any other names you may have been known by with also known as so-and-so, etc. Then you'll name your executor, which Maryland law calls personal representative. And we recommend for every job in the estate plan, including the executor and the guardians, if you have minor children, that you name at least one alternate, and maybe you could even name a second alternate if you want. Now, Byron, what's your take on having more than one person acting together as the executor?
Yeah, oftentimes people want to do this. I think especially if you have if your spouse is predeceased you and you have multiple adult children, people sometimes like to appoint, if your spouse is deceased and you have 2 adult children, you name both of them as co-PRs because you don't want to pick one over the other. This comes down to a matter of logistics, I think, and making sure that your estate is going to be probated as easily as possible. When you have to have 2 people sign off on everything, file everything, agree on everything, that can sometimes become problematic. I strongly encourage folks to just pick one. And if you need to have a conversation with your family members about why you did that, to ensure that there isn't any kind of strife or any kind of hard feelings about favoritism, do that.
Thank you. To be quite honest, in our firm, we charge a little bit extra when there are two personal representatives because it's always going to be more time consuming for us. It is what it is. All right, so letter C, state who gets your tangible personal property. And that 3-word phrase is our lawyer phrase for your stuff. Your tables, your chairs, jewelry, cars, boats, etc. And be careful, you need to make sure that you say who gets it if the first person you name doesn't survive you, if you have a backup person. Then in usually a separate paragraph from the stuff, but it could be combined, you will say who gets your real estate if you own a house or other real estate. And then in that same or separate paragraph, you should state who gets your money and other property. We lawyers often call the money and other property and real estate your residuary estate, residuary estate. So if you see that, that's what it means. Byron, any take on these last few items that we just discussed?
Just that you must always make sure that, even if you don't, if all you want to do is say, I want everything to go to my son, James, just make sure that you have a residuary clause. Because every now and then we have estates where it'll say, my bank accounts to so-and-so, my car to so-and-so, and there's a residuary clause missing. And what happens then, as we just talked about with the laws of intestacy, well, if there's money left over, let's just say you didn't specify how you want your real estate to be disposed of. Well, guess what? That gets disposed of by the laws of intestacy if there's no residuary clause.
Interesting. Okay, then to put the will into place, you're going to need to sign it, and you're going to need to date it, and you need to have 2 witnesses. Now in Maryland, it is not necessary to have a notary to notarize the will, especially in this pandemic time when it can be hard to safely get to a notary. You can validly do your will with no notary. Now that's not the case with the financial power of attorney, which we'll talk about later, but at least the will you can do with just 2 witnesses. And so here are a couple more tips. You always want to avoid anything ambiguous or that could be misconstrued in the language you use in a will. You always want to say what happens to the asset that you're giving away if the person you're giving it to predeceases you, meaning passes away before you. Usually your choices are that it can lapse, meaning that they don't get it and it doesn't go to their estate. Or you could leave it per stirpes or by representation per stirpes, and that means down the bloodline to the person's descendants. However, per stirpes does not mean to their spouse if their spouse survives them. It means their descendants. Okay. Also, if you want the personal representative to have discretion to divide things unequally, say so, because the law will presume that things should be divided equally if you just name several people. Finally, I think that it's unwise to specify a certain account number to a certain person rather than a certain dollar amount. Because if you leave a certain account to a certain person, then there may be ambiguity about whether that account shares in the estate expenses, etc. It just can sometimes get messy. So we encourage you to think of everything that you have as one single pie, and that you divide the pie in whatever fractions or percentages you want. I'm not discouraging you from leaving a flat dollar amount to a person, but we've just found a lot of messy situations when you leave specific accounts to specific people. And Byron, I don't know if you have any comment on that.
No, I think you've covered it.
Okay, then you want to name guardians if you have any minor children, which means under 18. And in Maryland, there are 2 types of guardianship. The person who's responsible for raising the child is called guardian of the person. And then separately, we have guardian of the property, and that is the person who's responsible for the money and finances of the child. And in some states, guardian of the property is referred to as a conservatorship. So if you hear that phrase, conservatorship, that's the same thing as what we call guardian of the property here in Maryland. Once again, remember, we want you to name a backup person in case the first one can't do it or stops being able to do it. All right, Byron has suggested that you put a funeral expense provision in the will. And so Byron, can you explain what that is?
Yeah, kind of what is often a kind of boilerplate provision in a will is it's what's called a funeral clause. And what that does is it authorizes the personal representative to, in their discretion, spend essentially as much money as they want on your funeral, memorial service, wake, you name it. And the reason I always encourage people to do this is if it goes above that, I think it's actually 15,000 now, Mark. That keeps changing.
Oh, okay. I didn't even know that. So thank you.
Yeah.
That's an illustration of that it does change. I think it was 3,000 or 5,000 when I first started.
It was 3,000, 5,000, 10,000. Now it's 15,000. You know, what we found is, you know, a casket alone can be $6,000, $7,000, $8,000. So it's 15,000. And frankly, it's up to you. It's your personal decision. It's your money. If you want to have a more, you know, a larger memorial service or funeral, that's up to you. But if it goes over that $15,000 amount, you have to petition the orphans court, and the orphans court would then have to basically, you know, they get to decide what is an appropriate funeral for you. And really, if you want to make sure that that stays in your family's control, put a funeral provision in, and you won't have that problem.
Great, thank you. Then finally on our list, we recommend in general that you waive the bond. The bond means that you have to take some of the estate's money. It's usually a few $100s, but it could be several thousand if the estate size is larger, and pay it to an insurance company to guarantee that the executor won't steal or misspend the estate money. If they do, then the insurance company has to pay it back, and then it's their problem to go chase the bad guy. But usually you have someone you trust to be the executor, so you can say in the will that you waive the bond. And in most cases, again, if you're not willing to waive the bond, then you should rethink whether that person really should be the executor in the first place, in most cases. Byron, do you have a different take on that?
No, you're spot on.
Okay, well, thank you. All right, so number 5, we have a short list of what things we do not think you should include in the will if you do it yourself. And the letter A is, I've seen too many times people putting things about funeral arrangements into the will. And then when does the will get taken out and looked at? Often after the funeral is already over. So if you have specifications, you've got to talk to your loved ones and joke about it at family gatherings, the ones that we can't have this year, but you just have to let them know what you want, because that way they'll be able to do it. Even if you just let them know, hey, I wrote a piece of paper about what I want and I keep it in such and such a place, you need to tell them that and remind them that. Okay, the second thing that we don't recommend is any conditions, such as if you say Johnny only gets X if he does Y, or Janie can live in my house for 3 years if she pays for the expenses. Folks, I'm telling you that these kind of conditions lead to ambiguity and arguments. And Byron, any comment on that?
Yeah, and kind of taken to an extreme, some of these conditions that you might want to put on a bequest aren't enforceable. So if you say, you know, I leave $10,000 to my son provided he gets married within 10 years, that's not enforceable. And I understand why you may want to encourage family members to, you know, live their lives in certain ways, but
and it's also not enforceable if you say I leave him money if he gets divorced from his awful spouse.
Right, or that they have children and they're raised in a particular faith. Those are the kinds of things that aren't, or, you know, occasionally we see a will where it requires, it conditions a bequest on someone marrying within a certain race. You know, those are the kinds of things that are, I would hope no one on this call would do something like that, but we see those things, not just in Howard County, but across the state, and those things aren't enforceable.
Now, but when Byron and I were talking about this, he reminded us, so we added to the list, that if you are disinheriting someone, meaning leaving them out, it is a bad idea to give a reason, because then they may be able to challenge that reason. It's also a bad idea to leave them $1, despite what you might have heard. when you leave them $1, you have made them a beneficiary of the estate, which it gets them the right to notices and involvement in the estate. So just say they are to be treated as though they had predeceased you and that they are to receive nothing. By the way, if the person you're leaving out has descendants, meaning children or grandchildren, you may want to specify whether they're deemed to be predeceasing you without issue, meaning that you don't want their money to go down the line to their kids. Or maybe you do. And then you would say that they're to be treated as though they had predeceased you with issue. All right, Byron, can you think of anything else that's come to your mind about what should not be in a will? Or is that pretty much wrap up our list?
I think there's just one other issue, and I don't think you and I had discussed this before, but after you have completed your will, after you've executed it and you've had witnesses sign it, do not make any notations, alterations, cross-offs, insertions. You want to change the amount that someone's going to receive. Please do not do that. Because number one, unless any notation on a will has to conform to the requirements for a will. So if I scratch out a bequest to someone, I've got to sign it and witness it as well. And usually what we see is we just had one the other day where this will had probably 15 different notations and none of them are valid. And I'm sure the decedent thought before they passed away that they would be. But if you want to make a bunch of changes like that, either write a new will or write a codicil, which is an amendment to a will.
Thank you for mentioning that. I see that too often, even in my practice. Okay, we need to speed along. We have a very long list of things that we'll go through very quickly, but this is really the important part of our workshop, probably the most important. And that is when your will should be complex enough that you should probably get legal help in doing it. And as you can see, as we run through these factors quickly, I would say that more than half of people in Howard County have one or more of these factors and probably should get legal help. So A, if you probably don't question your competence, but if you have a situation where you think people around you may question your competence, you should get some legal guidance. Next, if you own a family business or are part of a business, that's probably a situation where you should get legal help. Then if you know that there is dissension among your family and or you plan to leave things unequally to people who are, of equal status, such as your 3 children, that would often be a good idea to get some legal help. Next, if you're married, but you have 1 or more children from another marriage or another relationship, things are going to get messy if you don't get legal help with that. Next, if you want to protect the inheritance of your young children beyond age 21, you need to do a trust and you should see a lawyer. We have the Uniform Transfer to Minors Act, which makes it easy to leave money, but it maxes out at age 21. And there's nothing you can do to keep the youth from coming and getting it at age 21. Byron, any comments so far about those items?
Nope.
Okay. Next, if you have minor children and you have life insurance, you want to make sure that the life insurance isn't left directly to the children, because then it will go through a court supervised guardianship until they're 18. And probably even worse than that, that for their 18th birthday, they'll get a check for their whole inheritance of the entire life insurance policy. And usually that's not a good idea. So see a lawyer because we can help you do better. Next, if you want to protect the inheritance of your adult children at all ages in case the child gets divorced, you'll want to leave things in a trust that's written properly, and you should see a lawyer for that. Next, if you own real estate outside of Maryland or whatever state you reside in, or if you want someone to be able to live in your house, but just for a while, but not to get the house forever, again, a lawyer should help you with the drafting of that. Next, if you have significant debt, you may be able to specify things about it in the will and estate plan, and I think you should see a lawyer. Next, if you want to avoid the probate process through the court with a living trust, either to keep things private or for other valid reasons that you may have, a lawyer will be needed. Estate taxes in Maryland start at the $5 million level, so if you believe that your net worth is at or near that amount, you should get a lawyer's help. And finally, there is a Maryland inheritance tax that's separate from the estate tax. And it exempts people who leave things to their spouses or their ancestors, such as parents, or their descendants, such as children and grandchildren, and even exempts currently brothers and sisters. It does not, though, it also exempts things left to charity. It does not exempt your nieces or nephews or your friends. This is true regardless of how small your estate is. It is a flat 10% inheritance tax currently. And I recommend that you see a lawyer if the way you want to leave things is going to involve that. All right, we have about 5 minutes left to stretch things. So Byron, any comments on that list of things about when you should get a lawyer to help you with your will?
I think you covered pretty much everything, especially if you have a really high net worth. We have an estate right now, if you can believe it. There was a will, no trust, and it's a probate estate of $275 million.
Wow.
And it's
Wow.
this was a big real estate tycoon who passed away, and it's sort of amazing that he didn't have a trust, and that sort of gets into the privacy issue. You know, an awful lot of people don't need a trust, but you know, if privacy, you know, I think it's important to understand the probate process is a public process, right? So all the paperwork that comes through our office is public record. Now, for your peace of mind, it's not like we have, you know, some, you know, mob of people, you know, rummaging through estate files, you know, trying to, you know, find things on people. But if privacy is a big concern of yours, then the trust is going to be helpful.
Absolutely. Thank you for that. And by the way, anyone can look up, Maryland is pretty technologically advanced, and anyone can look up the records and filings of any estate online without leaving your chair. And if you want to order a copy of the actual document itself, you just put it on a credit card right there online, and it gets emailed to you usually within minutes. So it's much easier now for people to find things out about estates than the old days where you had to physically go down to the courthouse. Okay, we need to move along. I'm going to skip number 7 for the moment, and we'll come back to it because I think it's important to talk about where you should store the will and the other documents if you have them, which are financial power of attorney and healthcare documents. You can file them at the Register of Wills office. And what is it, Byron? $3 or $5 to file it?
It's $5, and we store. It's a confidential service. The contents of your will are confidential as long as we hold on to it.
So I rarely recommend that as the place to store it because I believe that when you do the will, you want to do a financial power of attorney and healthcare documents together. And the Register of Wills will only take the will, they won't take the other documents. So I think it's messy to store the different documents in different places. However, especially if you think somebody doesn't like your will and might try to get it and rip it up, it is going to be safe once it's at the Register of Wills office, and nobody is going to get it away from you. So that's a time that it can be good. In addition, if we look at paragraph D here, copies of all the other estate planning documents except for your will are widely accepted by the financial community. So you don't need really to have the originals of the other documents, but you need to store the original of the will itself in a safe place. So for that reason, it's not a bad idea to send your will to the Register of Wills office. And then when you do a codicil or a change your will, of course, you need to get it back and put the new one on file in its place. Some of our clients keep things in a safe at their house or in a safe deposit box, but do not use a safe deposit box if you're the only name on the signature card. You should have a spouse or an adult child or a sibling or a good friend or somebody else on the signature card at the safe deposit box, in my estimation. Byron, any comment on that? You have any differences?
Yeah, on the safe deposit box, the way it works is if we have this every couple of months, we'll have someone who, you know, a relative passes away. It's usually a parent, and they aren't sure where, like they know there's a will, or they heard one time that mom kept the will in the safe deposit box. You know, it's kind of a process. We've got to get a court order. I have to go to the bank. We've got to deal with the bank's legal department. I actually personally go into the vault to look at them to see if there is a will. More often than not, there isn't one. So it's sort of there's an expense. And if you don't have a key, the box has to be drilled. So if you're going to use a safe deposit box, that's fine. But as Mark said, make sure someone else is on the signature card and make sure people know for sure one way or the other what's in there. And the last thing I'll say, do not under any circumstance leave some of these other estate planning documents like your power of attorney or your healthcare directive in your safe deposit box. That's the last place those are things that you need people to have their hands on in case you are incapacitated or you're near the end of life. So the safe deposit box isn't going to do you any good. So make sure that those are easily accessible.
That's great advice. To say it a different way, those documents are needed while you are still living, whereas your will, conversely, is not really needed until after you pass away. So it is really hard to get into a safe deposit box. It takes the court order for them to get in while you're living if you can't get in. Okay, so thank you for that comment. I think we want to finish up by reminding you that there are other documents that are important in your estate plan, and these are the documents that are important while you were living. And they are a financial power of attorney to let someone do financial transactions for you. Or often in my recommendation to my clients, I recommend usually that they have two people acting together just as a safeguard and a check and balance against bad decisions while you're disabled. You can find Maryland state forms at this link that I have listed here on the Attorney General's website. There are actually two financial power of attorney forms on the website, a more general one and then a more limited one, and you can choose which one you want to use. Finally, I'm very pleased to tell you that the Horizon Foundation several years ago, which is sponsoring our workshop this morning, spearheaded and sponsors the speakeasyhoward.org website. It lets you do your healthcare directives validly online with no witness, no notary, no nothing. And it makes it easy for you to walk through their process if you go to that website. Also, if you've done written healthcare directives, the speakeasyhoward.org website lets you upload copies, PDF copies of the documents that you wrote, and it lets you print out a card for your wallet or your purse. And I won't go into this anymore because it was already covered in another workshop this week. But I've cited here to the website, the Attorney General's website, where you can go for the printed forms if you want to. So thank you for your time this morning. The main point was to describe the general process of what should and shouldn't be in a will, and when you probably should get a lawyer to help you through the process. Byron, I think I would like to invite you to say any final words of wisdom in hopes that you don't have to meet in person any of our audience this morning anytime soon.
Yeah, well, I really appreciate the Horizon Foundation. This is one of a couple of programs I've done with them, and they do a great service to the community trying to help us get this information out. I think in closing, I just want to say for everyone on this call, we've obviously thrown a lot of information at you, and it might feel overwhelming. For your peace of mind, I always tell people this, and this is not to prop up the legal industry or anything, but having some peace of mind is priceless. And so talking to a professional who has been dealing with this and can walk you through, really giving you a tailor-made that suits all of your needs estate plan, and knowing that everything is where it's supposed to be. My family will know exactly what to do when I pass away. It gives you, incredible peace of mind. Like I said at the beginning, I'm single. I don't have any kids right now yet, but I have a will, and it gives you peace of mind. There's that moment before you sign on the dotted line where you're a little hesitant, but I know that if something happens to me, my family will know exactly what to do, and that gives me a great peace of mind. So I hope that if you're thinking about going through this, that you think about talking to an attorney to make sure that you get comprehensive, solid advice.
Thank you very much, Honorable Byron McFarland, the Register of Wills for Howard County. Tiffany, thank you. And I guess we should ask the logistics of the people who have personal consultations later today, or maybe some for Monday. Remember, the personal consultation is not going to be with the goal of writing your will. It's going to be helping you do triage about whether you should have a lawyer help you or whether you think you can do it yourself. So Tiffany, what do people do? Do they just sign into a link?
Yeah, everyone who has one-on-one appointments this afternoon has gotten a confirmation email with a conference line in that email. So we actually ran out of appointments because a lot of you have great questions. But I know, Mark, you have said you'd make your information available to individuals afterward as well, right?
I will indeed, and we've set some time aside on Monday afternoon for additional consultations if anyone wants to get a hold of us at our law office.
Great.
We-
Yes, we will send out to anyone registered for any of the events this week, contact information for all of our presenters, links to all of the webinars, any of the slide content we can share, all of that will come in an email next week. So with that, I will say thank you to our presenters. Appreciate your time this morning. If there's nothing else, we can go ahead and end.
Great. Thank you so much.
Great. Have a great weekend, everyone. Thank you.
Thank you.